Most people think their phone is private because it's locked. It isn't. Not in the way you think. And the difference between Face ID and a passcode might be the difference between your case getting dismissed or your entire digital life being handed over in the middle of a flashing red and blue traffic stop. I've watched hundreds of body camera videos. I've sat through suppression hearings where prosecutors tried to sanitize what really happened on the roadside. I've seen judges lean back in their chairs and ask one quiet question that changes everything. And I can tell you something that most people don't realize until it's too late. The lock on your phone is not just technology, it's testimony. That's the phrase I want you to hold on to tonight. The lock is testimony. Because the law treats those two things, Face ID and a passcode, very differently. Not because of technology, not because of privacy policy, because of the Constitution. Imagine this. It's midnight. You're pulled over. The officer smells something he doesn't like. Maybe it's marijuana. Maybe he says it is. Maybe it isn't. He asks if you have anything illegal in the car. You say no. He asks if you mind if he searches. You say you'd prefer not. He stiffens slightly. The air changes. He asks for your phone. That's where most people freeze. You don't think about Supreme Court precedent. You don't think about the Fifth Amendment. You think about not making it worse. You think about going home. Your heart rate jumps. Your palms sweat. Your brain narrows to one question. If I just cooperate, does this end faster? And that's where this gets complicated. Under the Fifth Amendment, you cannot be compelled to give testimonial evidence against yourself. That's the foundation. That's the bedrock. The government can't force you to speak your own confession. But here's the nuance that most people misunderstand. The Constitution protects what's in your mind. It does not always protect what's on your body. Courts have long held that police can compel physical characteristics. They can make you provide fingerprints. They can take DNA. They can demand a handwriting sample. Those things are considered physical evidence, not testimony. But a passcode? A passcode exists only in your mind. Forcing you to reveal it is forcing you to use the contents of your mind to unlock evidence. And that is testimonial. The lock is testimony. That's why in many courts across the country, police cannot force you to tell them your passcode. They can ask, they can pressure, they can bluff, but they cannot legally compel you to reveal what you know, because that's protected speech. Now let's talk about Face ID, or fingerprint unlocking, or any biometric method. That's not in your mind. That's on your body, and that's where it turns. Several courts have ruled that police can physically use your fingerprint or your face to unlock a device because they're not forcing you to reveal knowledge. They're using a physical characteristic. It's the same legal reasoning as taking your fingerprints at booking. It feels invasive, but constitutionally, it's different. Now, this area of law is evolving. Some judges have pushed back. Some federal courts have recognized the deep privacy interests inside a modern smartphone. Remember, in Riley v. California, the United States Supreme Court acknowledged that phones are not just containers. They are digital extensions of our lives. They contain photos, messages, medical data, financial records, search histories, what the court called the privacies of life. But even with that recognition, the biometric versus passcode distinction continues to matter in courtrooms. And officers know this. Let me be honest with you. Officers are trained to exploit ambiguity, not maliciously in most cases, but strategically. If they believe your phone contains evidence, they will create urgency. We just need to take a quick look. If you've got nothing to hide, why not unlock it? We can get a warrant anyway. That's the script. I've heard it 100 times on body cam. Here's the trap. If you unlock your phone voluntarily, even for a second, you may have just waived your argument later that the search was unlawful. Consent is powerful. Consent cures a lot of constitutional problems, and courts will replay that body cam in slow motion and ask one question. Did he consent? The lock is testimony. If you hand over your passcode, you've testified. If you unlock it yourself, you've cooperated. And once that data is exposed, you can't unring that bell. Now, here's where this gets even more nuanced. Some courts have recognized something called the foregone conclusion doctrine. This is where prosecutors argue that they already know what's on the phone, so forcing you to unlock it doesn't reveal anything new from your mind. In other words, they claim it's not testimonial because they already know what they're going to find. That argument sometimes works. Sometimes it doesn't. It depends on how specific the government's knowledge is. If they can describe with particularity what files exist, they might convince a judge that your passcode isn't revealing new information. But in real life, on the side of the road, none of that matters in the moment. What matters is your composure. Because adrenaline is the silent enemy here. When police lights flash behind you, your body floods with cortisol. Your fine motor skills decrease. Your ability to reason narrows. You become more suggestible. That's not weakness. That's biology. Officers know that most people want to comply. Most people want approval. Most people fear escalation. This is where psychology enters. An officer may not yell, he may smile, he may soften his voice, he may make it feel casual. Just unlock it real quick. That tone can be more powerful than aggression because you don't want to be the difficult one. You don't want to look guilty. Now this is the part most people misunderstand. Asserting your rights will not always make the encounter smoother. That's the hard truth. If you say calmly, "I do not consent to any searches and I will not provide my passcode," the officer may become colder. He may detain you longer. He may call for a K-9 unit. He may seek a warrant. You might sit there for an hour. It might feel punitive. But inconvenience is not the same as guilt. And discomfort is not the same as legal failure. I defended a case where a young man was stopped for a minor traffic violation. The officer claimed he saw nervous behavior. He asked for the phone. The young man had Face ID enabled. He thought it would be harmless to glance at his phone while holding it. The officer took it from his hand and pointed it at his face. It unlocked. Inside were text messages that became the centerpiece of the prosecution's case. At the suppression hearing, the argument was simple. It was biometric unlocking. Physical, not testimonial. The judge agreed. Now imagine the same scenario, but the phone required a passcode and he refused to state it. The analysis changes. The lock is testimony. You see how small decisions create enormous consequences? Here's where it gets complicated again. Police can seek a warrant, and with a warrant, they may attempt to compel biometric unlocking. Some courts have allowed it, some have not. The law is still developing. But even with a warrant, forcing you to speak your passcode raises stronger Fifth Amendment concerns than forcing your fingerprint. So what do? You anchor yourself to one phrase, a simple, calm, unwavering sentence. I do not consent to any searches and I will not provide my passcode. You don't argue. You don't lecture. You don't cite case law roadside. You repeat it. The lock is testimony. Body language matters. Keep your hands visible. Move slowly. Don't clutch the phone protectively. Don't make sudden gestures. Your refusal should look calm, not defiant. Your tone should be steady, not sarcastic. Think neutral. Think composed. Think as if a judge is watching you later in a courtroom, which, by the way, they might be. And if they ignore you, if they take the phone anyway, you do not physically resist. You do not grab. You do not escalate. You repeat the phrase. You let your lawyer fight the legality later. Courts care deeply about whether you consented. They care less about whether you were frustrated. Now, let's talk about something uncomfortable. Some officers will imply that refusing makes you look guilty. That's a psychological lever. But exercising a constitutional right cannot legally be used as evidence of guilt. That's black-letter law. Yet in the moment, it feels accusatory. That's by design. The social pressure is intense. Here's what you have to understand. The Constitution was written for uncomfortable moments. It was not written for convenience. It was not written to make roadside interactions pleasant. It was written to create friction between government power and individual liberty. That friction can feel awkward. It can feel tense. But that's how it's supposed to feel. And here's the gray area. If your phone is unlocked when police seize it, different rules may apply. If they lawfully arrest you, they may seize the phone and seek a warrant. If exigent circumstances exist, like imminent destruction of evidence, they may argue immediate access was justified. These are fact-specific analyses. There is no magic script that immunizes you from every scenario, but the lock is testimony. A passcode forces you to reveal knowledge. A fingerprint or face scan reveals a physical characteristic. That distinction is where cases are won and lost. I want you to imagine something. You're sitting in a courtroom months later. A large screen shows body cam footage. The prosecutor pauses the video right at the moment the officer asks, "Can you unlock this for me?" The room is silent. Everyone watches your response. That 3-second exchange becomes the axis of the case. Did you say yes? Did you hesitate? Did you unlock it yourself? Or did you calmly say, I do not consent to any searches, and I will not provide my passcode? That moment matters more than you think. Let me tell you something else that's real. Officers are human. They respond to confidence, not arrogance, not aggression, calm confidence. When someone asserts a right clearly and respectfully, many officers will pivot. They may not like it, but they recognize it. The encounter often de-escalates when you don't argue, when you simply repeat the phrase without emotion, and you must rehearse it. Because under stress, you don't rise to your expectations. You fall to your training. If you've never said the words out loud, your brain may scramble. You may over-explain. You may justify. You may ramble. That's where accidental consent slips in. So you practice it, in your car, in your kitchen, quietly, until it feels automatic. I do not consent to any searches, and I will not provide my passcode. Slow, calm, unmoved. Now one more layer. Technology changes faster than case law. Courts are still grappling with encrypted data, cloud backups, remote wiping, and digital forensics. What seems settled today may shift tomorrow, but the Fifth Amendment's core principle remains stable. The government cannot force you to reveal the contents of your mind. The lock is testimony. If you remember nothing else from this conversation, remember that. Face ID feels convenient. It feels seamless. But convenience has constitutional consequences. A passcode requires memory. Memory triggers protection. Biometrics sit on the body. The body has fewer Fifth Amendment shields. This is not about hiding wrongdoing. It's about understanding leverage. It's about knowing how small technological choices interact with centuries-old constitutional doctrine. It's about recognizing that in a high-pressure moment, the calm repetition of a single sentence can preserve arguments your lawyer may desperately need months later. And I'll end where we began. Most people think their phone is private because it's locked. Privacy is not automatic. Privacy is asserted. It is preserved through friction. It is defended through calm refusal. So rehearse the phrase. Say it until it's automatic. Say it until adrenaline can't erase it. I do not consent to any searches, and I will not provide my passcode, because the lock is testimony, and testimony should never be given by accident.